Hello friends. You finally board your flight back to the United States after spending 2 weeks with your parents overseas. Your passport is ready, your documents are organized, you have made this trip before, so you expect another routine arrival. But after landing, an officer looks at your file, asks you to step aside, and tells you to wait for additional questioning. Suddenly, a trip that seemed completely normal begins to feel uncertain. Questions start racing through your mind. Did I bring the right documents? Has something changed? Will I be allowed back in? For many travelers, moments like this are rare, but when immigration policies change, even small misunderstandings can create unnecessary stress. But here is what most people still do not realize. A single immigration announcement can affect thousands of people in very different ways. The headline may sound simple, but the real impact depends on your immigration history, your visa category, your travel plans, and where your application stands today. That is exactly why understanding these changes before you travel is so important. Over the past several days, one immigration announcement has sparked concern among green card applicants, H-1B workers, international students, and families across the United States. Many people saw alarming headlines on social media claiming that green card applicants would now be forced to leave the country, or that traveling internationally had suddenly become much more dangerous. While those headlines certainly grabbed attention, they left out some very important details. The policy at the center of this discussion involves how USCIS plans to handle many future green card applications. For years, many eligible immigrants already living legally inside the United States were able to apply for permanent residence through a process known as adjustment of status. That process allowed qualified applicants to complete most of their immigration steps without leaving the country. Now, new policy guidance signals a different approach. Instead of treating adjustment of status as the normal path in many situations, immigration officers have been instructed to view it as something that should generally be reserved for extraordinary circumstances. For many future applicants, that could mean completing the final stages of the green card process at a United States embassy or consulate outside the country, through what is known as consular processing. That may sound like a technical legal change, but for real families, it could have very real consequences. Imagine a software engineer working in California on an H-1B visa. His employer has already started sponsoring him for permanent residence. His children are enrolled in school. His spouse has built a career of her own. Under the traditional process, the family expected to remain together while waiting for their green card case to move forward. If they are instead required to complete parts of the process overseas, the entire family's plans could suddenly become much more complicated. The same uncertainty affects international students, who later become eligible through marriage, workers sponsored by employers, and other immigrants who have spent years carefully following every immigration requirement. Their biggest concern is not simply filling out another form. It is wondering whether they may have to leave behind their jobs, their homes, or even their families for an unknown period of time. This is where many people make a mistake. Some people immediately assume that every new immigration announcement automatically applies to them. Others believe that because they already filed paperwork, nothing can possibly change. Neither assumption is always correct. Immigration law is highly fact-specific. The type of visa you hold, the date you entered the United States, whether you have already filed an application, whether you have maintained lawful status, and even the purpose of your original entry can all influence how immigration rules apply to your case. And before you make any travel plans, there is one issue that deserves even more attention than the green card policy itself. It involves what can happen when you arrive at a United States airport after traveling abroad. That is where many travelers discover that preparation matters far more than they ever expected. The moment your airplane touches down in the United States, your journey is not quite over. For many travelers, the most important part actually begins after they leave the aircraft. Every arriving passenger must go through inspection by CBP, the agency responsible for deciding whether someone can legally enter the country. Even if you have entered the United States many times before, every arrival is treated as a new request for admission. That is something many people do not realize. Holding a valid visa, an employment authorization document, or even a green card does not automatically mean you will be admitted without questions. In most cases, travelers are processed quickly and continue on their way. But if an officer needs additional information, they can refer someone to what is commonly called secondary inspection. Hearing those words can be frightening. Many travelers immediately assume they have done something wrong. In reality, secondary inspection does not automatically mean you are in trouble. Sometimes an officer simply needs more time to verify documents, confirm employment information, review travel history, or clarify answers given during the initial inspection. The important thing is to remain calm, answer questions truthfully, and provide documents when requested. This is where many people unintentionally create problems. Some travelers give rushed or inconsistent answers because they are nervous. Others try to guess what the officer wants to hear instead of simply telling the truth. Small inconsistencies about your employment, your address, your travel purpose, or your immigration history can lead to additional questions that might have been avoided. Preparation before your trip is often just as important as preparation during your interview. If you are traveling while an immigration case is pending, make sure you understand exactly which documents you should carry with you. Depending on your individual situation, that may include your passport, your visa if one is required for re-entry, your most recent approval notices, employment verification, travel authorization documents when applicable, and copies of important immigration records. Many immigration attorneys also recommend keeping digital and paper copies of important documents in case anything is lost while traveling. Having quick access to your paperwork can save valuable time if questions arise during inspection. Most travelers never need these extra documents, but the people who do often wish they had prepared in advance. Another common question involves long trips outside the United States. People sometimes assume that because they have permanent resident status, they can remain outside the country for as long as they want. Unfortunately, immigration law is more complicated than that. The length of your trip can sometimes raise additional questions about whether you intended to maintain your permanent residence in the United States. Officers may consider several factors, including how long you were away, where you work, where your immediate family lives, whether you continue paying taxes in the United States, and whether your primary home remains here. That does not mean every extended trip creates a problem. Many people travel internationally for completely legitimate reasons, including caring for family members, work assignments, education, or medical treatment. However, if your absence becomes unusually long without proper planning, you may face questions when returning. This small mistake can create serious problems later. Another issue receiving attention is international travel while a green card application or another immigration benefit is still pending. Some applicants believe they can simply leave the country whenever they choose and continue their case after returning. In certain situations, that assumption can become very costly. Depending on the type of application you have filed, departing the United States without the required travel authorization could affect your pending case. The exact rules depend on the immigration benefit involved, your current status, and the type of application that is awaiting a decision. That is why checking your individual circumstances before booking international travel is so important. A plane ticket is easy to replace. An immigration application is not. Another concern many viewers have raised is electronic devices. Can immigration officers inspect your phone or laptop? The answer surprises many people. Under existing border authorities, CBP officers have the legal authority to inspect electronic devices under certain circumstances at ports of entry. While these inspections are relatively uncommon compared with the total number of international travelers, they are permitted under agency policy. Officers may conduct either a basic inspection or, in limited situations, a more advanced examination consistent with applicable laws and procedures. That does not mean officers routinely search everyone's devices. Far from it. Most travelers complete inspection without any issue at all. But understanding that these authorities exist helps people prepare realistically rather than relying on rumors circulating online. Another frequent question is whether social media activity can affect immigration decisions. This topic often generates confusion because people hear dramatic claims on the internet. The reality is that immigration officers evaluate many different sources of information during immigration processes when authorized by law. Consistency matters. If information provided in applications conflicts with other available evidence, officers may ask additional questions. The best approach has always been the simplest one: be truthful, be consistent, keep accurate records, and never submit information that you know is false or misleading. As these new green card policy discussions continue, many travelers are wondering whether international trips should be postponed altogether. There is no single answer that applies to everyone. For some people, travel may continue exactly as planned, with no issues at all. For others, especially those whose immigration status is changing or who have applications pending, it may be wise to review their situation carefully before leaving the country. This is why immigration professionals rarely give blanket advice. Every case is different. Your visa category matters, your travel history matters, your pending applications matter, and your future plans matter. Understanding those details before you board your flight is far easier than trying to solve unexpected problems after you arrive at the airport. But airport inspections and green card processing are only part of the story. Another issue creating concern for thousands of skilled foreign workers is the growing discussion surrounding H-1B filing costs, employer expenses, and what these changes could mean for future hiring decisions. That part of the story is just as important, because even people who never plan to travel internationally could still feel the impact. For many skilled professionals, the H-1B program is more than just a work visa. It represents years of education, career planning, and the hope of building a long-term future in the United States. Thousands of engineers, software developers, healthcare professionals, researchers, financial analysts, and other highly skilled workers depend on this program every year. That is why even small policy or fee changes attract so much attention. Recently, many viewers have been asking the same question. Are H-1B fees increasing again, and will that affect my job? The short answer is that employers have seen higher filing costs in recent years, and those costs have become an important factor in hiring decisions. Depending on the type of petition and the size of the employer, government filing fees can vary significantly. Some employers may also choose optional premium processing if they need a faster decision, adding another expense to the overall cost. This is where many people become confused. The higher filing costs do not automatically mean fewer jobs will be available. Many large companies continue to sponsor international talent because they need specialized skills that are difficult to replace. However, for smaller businesses and startup companies, higher immigration costs can influence hiring budgets and long-term workforce planning. That does not mean the H-1B program is disappearing. It does mean employers are paying closer attention to every sponsorship decision they make. Another common misunderstanding involves who is legally responsible for these costs. Many workers believe they can simply pay all of the government filing fees themselves if their employer is hesitant. In reality, federal regulations require employers to pay certain mandatory fees associated with an H-1B petition. There are also strict rules designed to prevent employers from improperly shifting required costs onto employees. This is not just a recommendation. In some cases it is federal law. If someone asks you to pay fees that the employer is legally required to cover, that situation deserves careful attention. Before agreeing to any arrangement, it is wise to understand which costs may legally be paid by the employer, and which optional expenses may be handled differently under the applicable regulations. Another question we hear all the time is whether higher filing costs will reduce H-1B approvals. The answer is not necessarily. Approval decisions are based on eligibility requirements, supporting evidence, compliance with immigration law, and the facts presented in each petition. Filing fees alone do not determine whether a petition will be approved or denied. However, higher costs may influence how many petitions some employers choose to file in the first place. That distinction is important. One issue affects business decisions, the other affects legal eligibility. They are not the same. Now let's move into some of the questions our audience has been sending us over the past few days. One of the most common questions is this. If my green card application is pending, should I cancel my international trip? The honest answer is that there is no universal rule that fits every case. Some applicants may be able to travel if they meet all legal requirements and have the proper travel authorization. Others could face significant complications depending on the type of application they filed and their current immigration status. This is exactly why checking your situation before purchasing a ticket is so important. Another viewer asked, if I already have an H-1B visa, Do these green card policy changes automatically affect me? Not necessarily. Many H-1B workers continue to benefit from the dual intent nature of their visa category, which recognizes that someone may work temporarily in the United States while also pursuing permanent residence through lawful channels. That does not mean every case is identical, but it does mean H-1B workers often operate under different legal rules than people holding visas that require purely temporary intent. Another question appears almost every day. Can airport officers deny me entry even if my visa is still valid? A valid visa is an essential travel document, but admission into the United States is ultimately determined by CBP officers at the port of entry after reviewing your documents and confirming that you remain eligible under immigration law. For the overwhelming majority of travelers with proper documentation, the inspection process is straightforward. But understanding how the process works helps reduce unnecessary surprises. Another viewer asked, "What if my passport expires soon?" Many countries require passports to remain valid for several months beyond the date of travel. Airlines may also refuse boarding if passport validity requirements are not met. Before booking any international trip, verify your passport expiration date and review the entry requirements that apply to your destination as well as your return to the United States. Here is another important question. Should I carry immigration documents in my checked luggage? Whenever possible, important immigration documents should remain with you in your carry-on baggage. If checked luggage is delayed or lost, having immediate access to your passport, approval notices, travel authorization, employment documents, and other essential paperwork can make the inspection process much smoother. One viewer also asked, "Can changing jobs affect my immigration case?" The answer depends on your specific immigration category, the stage of your application, and the rules governing your petition. Some employment-based immigration cases may allow certain changes under existing law, while others require additional filings or approvals before changing employers. Never assume that changing jobs has no immigration consequences, without understanding how the law applies to your case. Perhaps the most important question of all is this. Should I panic? The answer is no. Immigration policies change regularly, new guidance is issued, court decisions reshape existing rules, agencies publish updated procedures. None of that automatically means your case is in danger. The biggest mistake is making decisions based on fear instead of facts. Reliable information will always be more valuable than alarming headlines. Before making major decisions about travel, employment, or immigration filings, review the latest guidance from the appropriate government agencies and, when necessary, consult a qualified immigration attorney who can evaluate the facts of your individual case. As we have discussed today, the immigration system is constantly evolving. Green card processing policies are changing. International travel requires careful preparation. Airport inspections remain an important part of every arrival. H-1B employers continue adapting to higher filing costs and evolving regulations. And every immigration decision should be based on accurate, up-to-date information, rather than online rumors. In just a moment, we'll bring everything together with a quick recap of the most important points you should remember, along with a few simple steps that can help protect your travel plans, your immigration status, and your future in the United States. Before we wrap up, let's bring everything together because the biggest takeaway from today's update is not about fear, it is about preparation. If you remember only one thing from this video, remember this. Immigration rules can change much faster than most people expect, but informed decisions are almost always better than rushed reactions. Today we covered several developments that have raised understandable questions among immigrants, international workers, students, and families across the United States. First, the proposed shift in how many green card applications may be processed has created uncertainty for people who expected to complete the entire process while remaining inside the country. While the policy guidance suggests that adjustment of status may be treated differently in many future cases, it does not automatically mean every applicant will be required to leave the United States. Every immigration case depends on its own facts, the applicable law, and the latest government guidance. Second, international travel deserves more attention than ever if your immigration status is changing. Before booking a flight, take time to review your documents carefully. Make sure your passport is valid, confirm that your visa remains valid if one is required for your return, and verify whether you need additional travel authorization based on your specific immigration situation. Many people spend weeks planning a vacation, but only a few minutes reviewing their immigration documents. That can be an expensive mistake. Something as simple as an expired passport, missing approval notice, outdated employment letter, or misunderstanding about your current immigration status could create delays that are entirely avoidable. Third, remember how the airport inspection process works. When you arrive in the United States, CBP officers are responsible for determining whether you meet the legal requirements for admission. Most travelers complete this process without difficulty, but officers may ask additional questions or request supporting documents if they need to verify information. If that ever happens, remain calm. Answer every question honestly. Do not guess if you are unsure about something. If you do not understand a question, politely ask for clarification. Staying respectful and truthful is always the best approach. Fourth, we discussed H-1B workers and filing costs. Higher government filing fees may increase the financial commitment for employers, particularly smaller businesses. However, higher costs alone do not determine whether an H-1B petition will be approved. Approval still depends on eligibility, supporting evidence, and compliance with immigration law. For workers who are already employed in the United States, this is an important reminder to maintain communication with your employer, stay informed about your immigration timeline, and keep copies of important employment and immigration records. Organization matters more than many people realize. One missing document may not seem important today, but months later, it could become essential when responding to a government request or preparing for international travel. That is why experienced immigration attorneys often encourage clients to keep a complete immigration file. Include copies of your passport, previous visas, approval notices, receipt notices, employment letters, tax documents when applicable, travel records, and any official correspondence from immigration agencies. Think of it as protecting your future. You hope you never need every document, but if you do, you will be grateful they are already organized. Another important lesson from today's discussion is to be cautious about where you get your information. Social media has made immigration news travel faster than ever before. Unfortunately, misinformation spreads just as quickly. A short video or dramatic headline may leave out critical details that completely change the meaning of a policy announcement. Sometimes a proposed rule is presented as if it were already fully implemented. Sometimes one person's unique immigration experience is described as though it applies to everyone. And sometimes, outdated information continues circulating long after government agencies have issued new guidance. This is why relying on official sources is so important. When major immigration announcements are released, read information from USCIS, the Department of State, or other official government agencies whenever possible. If your case involves complicated legal questions, seek advice from a qualified immigration attorney who can evaluate your specific circumstances instead of relying on generalized advice found online. No two immigration cases are exactly alike. A detail that seems minor to one person could completely change the outcome for someone else. That is why comparing your case to a friend's experience can sometimes lead to the wrong conclusion. As we move through the rest of 2026, immigration policies may continue to evolve. New guidance could be issued. Court decisions may clarify existing rules. Processing procedures may change. Filing requirements may be updated. That is simply the nature of the immigration system. The people who usually navigate these changes most successfully are not necessarily the ones who know every law by memory. They are the people who stay informed, prepare carefully, keep accurate records, and make decisions based on verified information instead of fear. Whether you are waiting for a green card, working on an H-1B visa, studying in the United States, planning your next international trip, or helping a family member through the immigration process, your best protection is knowledge combined with preparation. Thank you for spending your time with us today. We know immigration news can sometimes feel overwhelming, especially when policies seem to change overnight. Our goal is to break down these complex updates into clear, practical information That helps you understand what is happening and what steps you may want to consider next. If you found this video helpful, share it with your family, friends, co-workers, or anyone whose immigration journey could be affected by these developments. You never know who might avoid a costly mistake simply because they received accurate information at the right time. And if you want trustworthy immigration news, practical travel guidance, visa updates, and easy-to-understand explanations of important policy changes, be sure to subscribe to the channel and turn on notifications so you never miss future updates. Thank you for watching, stay informed, stay prepared, and we will see you in the next video. Before you go, let's answer a few final questions that have been coming up repeatedly because they highlight just how much confusion still exists around these immigration changes. One viewer asked, if I already filed my green card application, should I expect an immediate change to my case? Not necessarily. Immigration policies often involve implementation guidance, effective dates, and individual case reviews. If your application is already pending, avoid assuming that a headline automatically changes your situation overnight. Continue monitoring your case through official government channels and respond promptly to any requests for additional evidence or interview notices. Another question we hear frequently is, should I postpone my travel plans until everything becomes clearer? The answer depends entirely on your individual circumstances. If you have a pending immigration application, an upcoming interview, or questions about your travel authorization, it is worth reviewing your case before booking an international trip. A little preparation today can prevent major complications tomorrow. Someone else asked, can these immigration policies change again? Absolutely. Immigration policy is one of the fastest changing areas of federal law. New agency guidance, court decisions, executive actions, and legislation can all affect how certain rules are interpreted or enforced. That is why staying informed is not something you do once. It is something you continue doing throughout your immigration journey. Another common question is, what is the biggest mistake immigrants make during times of policy change? For many people, it is acting too quickly based on rumors. Some rush to travel without understanding the possible consequences. Others delay important filings because they believe inaccurate information they saw online. And some panic after reading social media posts that leave out critical facts. The better approach is simple. Slow down. Verify the information. Read updates from official government agencies whenever possible. And if your situation involves important legal decisions, speak with a qualified immigration attorney before taking action. Remember, immigration is rarely one size fits all. Two people with the same visa category can have completely different outcomes because their immigration history, travel records, employment, or family circumstances are different. That is why comparing your case to someone else's experience can sometimes create unnecessary confusion. If there is one message we hope you take away from today's discussion, it is this. Preparation is always more powerful than panic. Keep your immigration documents organized, review your travel plans carefully, stay aware of policy updates, and make decisions based on verified facts instead of speculation. Whether you are waiting for a green card, working under an H-1B visa, studying in the United States, visiting family overseas, or simply trying to understand how these developments could affect your future, staying informed is one of the smartest investments you can make. We'll continue following these immigration updates closely and explain what they actually mean in plain, practical English, without unnecessary fear or confusing legal language. If you found this video valuable, please share it with someone who may be affected by these changes. It could help a friend, a coworker, or a family member avoid an expensive mistake or make a better informed decision. And if you want reliable immigration news, visa updates, green card guidance, travel alerts, and practical explanations of important policy changes, make sure you subscribe to the channel and turn on notifications. We publish accurate, easy-to-understand updates designed to help you stay informed, stay prepared, and protect your future in the United States. Thank you for watching. Take care of yourself, take care of your family, and we'll see you in the next video.